Depositions. Oftentimes, it's the single word that instills more fear into a client's heart than anything else during the case, because it's kind of when they're under the spotlight, so to speak. It's the chance for the other attorney to sit down and ask you a bunch of questions about what happened in your life since the incident. And it can be very, very scary and very, very intimidating. So today we're here to talk about depositions and why you shouldn't be scared if you just follow your lawyer's advice.
Hi everybody, this is Eric Mausner and Tom Graham, personal injury lawyers in Miami, Florida. On this channel we talk about all things related to personal injury, various tips and insider information. Thanks for stopping by.
So I think for most of our clients, the number one most concerning or challenging day in their case is the deposition. Because what is the number one fear of most human beings? It's public speaking. And in a deposition, you have to speak in front of people you don't know in a situation that's not comfortable for you, that you've not been in. There's a court reporter, there's someone typing, oftentimes it's videotaped, and it can be very scary and very challenging. And I think a lot of clients feel that, and they put a lot of pressure on themselves because they feel like they need to win the case at the deposition, which isn't necessarily true. It's partly true, but it's not really fully true. Where does it happen, who's there, and what is it for? So before the Zoom era, I'm gonna call it, it was always in person. And now we do a lot of these things on Zoom, which is a bit more convenient, but there's always going to be a certain group of people there. So the witness, or if you're the plaintiff and it's your deposition, you'll be there. Your attorney will be there next to you. The defense attorney will be there asking you questions. There's going to be a court reporter. That's a man or a woman that's going to be typing down all the words that we say and making it into a little transcript or booklet. And oftentimes there's even a videographer, someone taking a video of the deposition. And if the defense wants, they can bring a party. Any party can sit in on any deposition. But the usual cast of characters are witness, two plaintiffs, court reporter. And if it's not on Zoom, it'll usually be in an office or at a court reporter location.
So I always like to tell clients the way to get through the deposition is preparation. Clients will get nervous when this day comes, but as long as your lawyer is preparing you a month in advance, a week in advance, or even a day before, whatever is required to prepare you, then you're going to be just fine. But it is about preparation, just like anything else in life, especially law. A deposition is one of the most important days for the client because the other side is evaluating you. It's your opportunity to talk about your background, the liability facts, what happened, and then of course your damages and your injuries and how it affects your life. So your lawyer needs to go through those various areas of the deposition, and that's generally how it's going to flow for a plaintiff's deposition. And the lawyer can prepare you on this, compare you on your damages and injuries and your medical records. They can prepare you on how the case, you talk about how the case affected your life. You can talk about the facts, how the injury occurred, the medical causation, the mechanism of injury, all these things that you want to be clear about when you're responding to the defense attorney's questions.
Good point. And beyond all that substance, also the deposition is the time for the defense attorney and the defense team to kind of get a look as how you are as a person, right? So how do you present? Are you able to speak and do a nice job talking? Do you get angry or disrespectful? And they're also 100% testing how honest you are. Most of the questions, especially for a lot of the first part of the incident, they're going to know. So all your background information, they're basically going to know that. And they're trying to see, can they catch you in a little white lie? Because if they do, then you're totally done. So a lot of it is the human element of being yourself, presenting nicely, and just communicating in a respectful and comprehensible manner.
Yeah, the defense attorney and the insurance company is looking at you and they're determining likability. Will a jury like you? Will a jury think you're honest? Mm-hmm. If you're not a likable person, and there's plenty of those out there, you might not present well in front of a jury. And if that's the case, settlement is probably the next thing everybody's thinking, so you don't lose the case in front of a jury.
And what do we see? Oftentimes we see, how will they test this? Sometimes they'll make your deposition go on 6, 7, 8 hours, try to wear you down. They'll re-ask the same question 10, 20 times, try to get you a little angry. They'll ask you insulting or personal questions, kind of poking at you, because they want to see, can we make this person have a response? And they're also trying to beat you down and intimidate you so that you want to get out of your case and you just want to sort of escape. But if you're well prepared and you know what you're doing, you have a good attorney, you don't have to fall into their traps. Now, in my experience, most attorneys and most defense attorneys in these types of cases, they have a job to do. They're trying to do a good job. It can be a hard job. And most of them are going to be decent and honorable and respectful. And they're not going to waste your time on purpose, typically. Most people. But there are a few, and they like to cut ethical corners just to mess with you. It's like anything else. Maybe you get a bad apple as your defense attorney, and they're not a nice person themselves. And if that's the case, and they're harassing you, they're dragging the deposition on for no good reason, they're asking the same question, or they're asking really crazy questions that have nothing to do with your case just to embarrass you, then we can put a stop to it. We can stand up for you and say, enough is enough, deposition's over, we're going to a judge. That doesn't happen very often, but you know, if it does, you need an attorney that knows how to handle the situation, that's going to speak up, lodge the right objections, and shut down the BS, so to speak. We've all seen the many shows and movies about depositions and lawyers trying to get that aha moment or asking about things that are super embarrassing and not even related to the case. The law is that in depositions, in discovery, you have wide latitude to ask about a lot of things. So most things are fair game. But if you cross a certain line, then it becomes harassing. If it's clearly irrelevant and you're harassing the person, we can put an end to that. But typically the best thing to do is just be confident in yourself, answer the question truthfully, and if you do that and you maintain your composure and don't get angry, you're not going to look bad. That defense attorney is going to look bad. So one of the biggest issues or problems we'll run into, and most of our clients do a nice job of listening to our instructions, but sometimes we get clients that think that they are or they need to be the smartest person in the room, or they need to win their case, or they need to win the argument. And that's the worst way to come into a deposition, is thinking like that. Because you're not going to sit in there and need to outsmart everyone. You don't need to be the smartest person in the room. What you need to do is listen very closely and answer the question on point from an honest place. And you don't need a lot of fluff or irrelevant facts. You don't want to throw out unnecessary information. You don't want to tell stories about your life that don't relate to what they're asking. Most of these things, you need a sweet, short answer, or even a yes or no answer answers a lot of the questions. And where we see clients get into trouble is when they go too far, they try to tell stories, or they think they're smarter than all the attorneys, they can outsmart them, they need to outsmart them. You don't have to do that. You don't have to do that.
Yeah, you're being evaluated, and you definitely want to answer the question that's being asked. You don't want to give too much information. And then, common sense things you want to address professionally. You want to be respectful. You want to make eye contact. You want to use sir or ma'am. You want to be likable. You are being evaluated, and you want to be careful in how you present and how you answer your questions. And your lawyers will prepare you thoroughly how to answer those questions. There's a lot of rules and tips and tricks to make sure you're answering questions properly.
And remember, the point of this isn't for you to be tortured in there. So you can sit, listen to the question, and if you need to take a minute before you respond, that's totally fine. And anytime you want to take a break, you need to use the restroom, get a glass of water, we let our clients take as many breaks as they want because we want their mind fresh. So you're not in this situation where you're totally locked to your chair and in a stress interview. It's not that way, and we can make sure you feel comfortable, and we'll work with you to make you feel comfortable. So what is the best outcome from a deposition? The best outcome, in my view, from a deposition is that you answer the questions in a straightforward, comprehensible way, and the defense attorney walks away saying, they were honest, they were likable. I'm going to go tell my client that they seem like a good person. I believed what they had to say.
Yeah, I think, and in that deposition, you were clear and articulate about your liability and your damages and injuries, so the lawyer can walk away and talk to the insurance company, and they can make a proper evaluation of your case.
And just remember, you're not the one with all the weight of the world on your back when you're in your deposition or in your case. The lawyers are going to do a lot of the heavy lifting, 90% of it for you, and we're going to have other witnesses and other experts that are going to be testifying. You don't need to know everything, okay? And you don't need to say everything. All you have to do is tell the truth and listen to your lawyer's instructions.
Thanks for stopping by our channel. Eric Mausner, Tom Graham, personal injury lawyers in Miami, Florida. Please follow, like, subscribe, stop by for all kinds of inside tips on personal injury law.
Great.